Corpus. So this is a recap, really, to put all of the information that we've got, all of the evidence, the witness statements now, in the case file number 2021-000/0004. Now, we were just obviously outlining, this is to exemplify and help people get their heads around what this hierarchy system of administrative fraud really is, and how it appears legal, and obviously, like MFN 128 just said, it is to get to the point where the administration system has proven itself unlawful. We already know it's unlawful. They already know it's unlawful. And what's actually come out of this, the whole idea of this, was to exemplify to our own minds, really, and to the creditors of people who have had their minds scrambled, let's say, with legal being lawful, which includes all of us at some point in our lives. And it's just whatever it is that it takes to defeat that belief that we all credit. It depends obviously on how strong we invest and credit our belief that it has got any kind of standing. Obviously the position that we're in now, they've already stamped a document, well, put an electronic signature on it, let's call it, but what can you expect? Can't expect anything more than that. Anyway, outlining their out and out right inability to perform what it is that they're advertising. So think as a company now, here I am as a company, and you come to my shop and you have created a contract with me. You've been forced to create a contract with me, first of all, because I created an administrative system that breaks the law. And through me teaching you that this was the law, you have all been crediting it and accepting it and paying into it and contracting with it. And so you've accepted my terms and conditions, but I didn't disclose the terms and conditions fully to what it was that you were getting. So immediately it's gross misrepresentation, even on a company to company basis or company to customer basis. So anything, and you'll hear that on the video, anything that comes from an origin of fraud cannot have any kind of CPR process. Now, these things have been bouncing out at me all weekend. And what is it that we call something when we resuscitate somebody who is dead? CPR. And this is what the universe is yelling at us. Look and see the words, what it is that you're creating when you use these words that you've never really given any consideration to. It's just crown procedure, whatever it is, procedure rules, whatever. And that's how much credibility we give it. But to have somebody actually exemplify their stoic belief in this system. So here I am as my shop. If I sell a remedy, I sell a solution, okay? But I don't have a product unless I create the problem. So if the administrative system did not exist at all and was not credited by any single one of us ever, then we would never need a habeas corpus, a release from the unlawful incarceration of it. So what this, I could kiss this woman, I really could, for what she's actually done. And I never imagined that we would get such a receipt, but obviously I've said this many times now. And we're going to go through it bit by bit. So but obviously, instead of me determining, I'm going to determine what this means to all of us, I wanted to ask the MFNs who are here, obviously, because this is what a court or a hearing or a judicial review or an application for a hearing, all the evidence should be publicly available. All of the information about people's perspectives, where they're coming from at this, why it is that it's interpreted the way it has got to be re-ministered in a way where it is not by someone appointed on behalf of others, and that is obviously is what we're going to see as we go through this. You cannot lawfully appoint somebody else to act on your behalf, and but somebody, it has to be recognized. I can't turn around and say to you, I don't recognize you, but I recognize you don't need a habeas corpus. So we're going to go through the fact that obviously if the administrative system didn't exist in the first place, nobody would be needing a habeas corpus. And the real eye-opener, I hope for a lot of people, is the fact that there is a process, excuse me, already in place, implying that there will be a need at some point by the people who to apply for some writ or piece of paper or somewhere to rebut the presumption that unlawful incarceration is okay, and under the administrative system, that is exactly what it is that they are implying, that I can unlawfully incarcerate you with my CPR rules and my process, my litigation, my claims, the use of my legal fictions that you've all used without a right of use. You came and you bought my product from my shop down the road, and then you've come to my other shop to tell me it doesn't work and that it's cost you all of these rights, liberties, freedoms. And then I'm going to come and say, actually, Minister Van, I don't recognize you in my administrative system. And so you don't exist. So I can't give you the thing that you're saying you need, because really you don't need one. Because you are already unlawfully incarcerated, true? Are you subject to COVID acts and statutes legislation? No, you've just stipulated that. So really, what is it that you're asking me to do here? Well, we're asking you to do here is exemplify your complete hypocricy, your presumption, your invalidity, and your failure to be able to perform on a public platform, citing public equity while being responsible for using the exact thing that you've now said is not valid to lay a claim with, be it COVID or be it MOVN. You've used both. And so what that actual forum scenario setting was created for, this is the restoration of rights. This is what it takes for you to be able to get to that point where they have destroyed themselves with their own seals, signature stamps, logos. They have breached universal law themselves by openly using something that they didn't have the right of use of. And what you all did there is you forced the apocalypse, the disclosure of their non-disclosure. You forced them to disclose that, first of all, I have no bar standard. I can make a claim, but I can't make a claim. I can use this thing to make a claim against somebody with, but I can't, that somebody else can't use it. Now, the word litigation, to litigate, to make a claim. So I cannot, as Judge Stein, sit there and say, I cannot recognize Minister MOVN at all as needing a habeas corpus and to make a claim for a habeas corpus. But then I've used I could recognize Minister MOVN as being in a prison. Then, because then I've attached a prison reference number to it. So now I've breached my own terms and conditions of the administrative system being ever appearing to be able to exist by only existing because it was there to prevent the right of the use of somebody else's or some equity that had been assigned into a trust. Now, I've had a very funny weekend where people have been contacting me about some slag spoof group where we've got Karen Hamlin and others in there talking about the fact that she didn't even use trust law. We just took out mercantile law and trust law. And what they did is they had to go and get a representative of their level of that panel of the House of Lords to come to judge a scenario inside their system that involved ministers. Now, the effects of the habeas corpus were already felt. It's true. Didn't need a habeas corpus. And the irony is they can't give us a habeas corpus because of the administrative system, not Queen's Bench. Why can it not go across into Queen's Bench? Because there you are. You've got the administrative system holding ransom and by man-made definition, the law and your rights. I can legally, unlawfully incarcerate you. And when it's drawn to my attention, I have to drop you like a hot potato. I don't have to drop you like a hot potato if you use a legal fiction that I can launder, that I have got the right of use of. But even at that level now, I can't consider it as a claimant. I cannot use it to utilize it. Now, this is utility transmitting accounts is what I'm talking to you about, what I've always been talking to you about. This process is a quiet title. Minister Emma Venn quietens the presumptions that any claims can be made by anybody using it and against anybody using it. The word is body. Now, she evidenced Minister Emma Venn as being not incommunicado. She evidenced him as being alive. She evidenced him as being Minister Emma Venn 128, and that was enough to warrant the fact that he now didn't need a habeas corpus. That constitutes one of the most perfected evidence of life with her signature on it, that of Minister Emma Venn existing in ever. Really ever. And then to write, I can't recognize Minister Emma Venn or universal law or a legal fiction that actually is Crown copyright, because it's got all rights reserved and it's got all of the equity assigned away from it. I can't utilize it, is what she's saying. I can't use it. Usury. I cannot, you are of no use to me, you useless thing, Minister Emma Venn. Now, good.
That's an insult.
Well, it's
no,
I would you want to be of use to
no,
a system
I'm
of
just
fraud?
joking. I feel like I'm useful, but not to them.
You're very useful to universal law, but universal law doesn't use you. It
No.
replenishes you and sustains you. It feeds you. It nourishes you. It supports you. It doesn't come along and use you and diminish you and parasite off your energy and prosecute you for profit. That's another part of our paranormal self, our illegal self that has clung on to any structure that it could. Okay, here I am flying through chaos, don't know who the hell I am, where I'm from, and I'll grab onto the nearest thing that comes along that looks like it's something real. Well, bloody hell. That's the best that we could come up with. I'll just grab on to diminishing myself as a Vatican debt slave. And that's what she was telling you, is that I cannot recognize you as a Vatican debt slave that needs a habeas corpus writ to be free from a system that you are not recognized in. I can recognize you to that level. But in actually doing that, what she did. And that's why I couldn't believe it. And it was a natural response. I should have really just shut up and let her carry on incriminating herself, but it was a natural response for her soul to say, I need to stop you right there and reserve your rights, because of what you're just about to do, to incriminate yourself in such a degree that she just made her whole system obsolete. She completely.
So by you saying that and giving her the opportunity to remedy the situation, she has further compounded the situation, hasn't she?
She was put on notice. It was the same as we put the police on notice. That judge, or whatever she wants to call herself, was put on notice that if you go any further, if you continue, you're going to incriminate yourself. That's it. So you've now got the right to remain silent, and anything that you do say further, you're going to incriminate yourself by. And she just went for it. Now,
did a great job.
Now, do you think at that point she knew what she was doing?
I don't think at any point she knew what she was doing. Do you?
No.
No. I wonder, somebody at some point must know what the whole system is and how it's set up and how it's set up to be fraudulent. I mean, you've clearly demonstrated that with using the the M of N title. So at which level does this fraud originate at?
Depends how big your fraudulent mind is crediting it, doesn't it? I mean, it's taken this to get you guys, the apodixy, the receipt, to convince you that Minister of Event is a quiet title. Minister of Event cannot have charges laid to it. What's going to happen tomorrow when we've got the evidence? So here she is over here, Judge Stein saying Minister of Event can't be used for litigation is what she's actually signed off on.
Yeah.
So how can Minister of Event be used in litigation tomorrow in Hereford County Court?
Brilliant.
It cannot.
Well, they're acting in ignorance, and they don't know yet.
They're going to get the document served on them tomorrow.
Tuesday.
Oh, sorry. That's why my internet's not working. I thought it was the 15th. Oh, these days are just galloping away, I'm telling you. Anyway, these days are galloping away. So whatever day it is, it's going to be a really great day. The day that they actually get served up themselves, their own signature from their own lady of the ship, stating you can't do the thing that you're doing. And so this is has everybody got a pen and a piece of paper? Because I think this is really important for people to comprehend about killing. How do you restore your rights? So they refused our offer of settlement. So there's a fair few things that we need to go over. But first of all, let's start off at the place where when she said the massive costs in the document. Shall I put that up? Shall I see if I can get the document onto the screen while I'm talking at the same time? And said that the massive costs about what it is that we've done. Now, we made the offer of settlement, obviously, against the 10 quadrillion. It was quite telling that she said all of it. That, are we offering all of it? And no, just part of it. Now, how these debts came about, they now can't say that they don't know how these debts came about, because first we're going to look at how they make money from persecuting people for profit. So obviously we all know that they can lock you up unlawfully using administrative CPR because you breathe life into the dead fiction for them and said, I'm the liability holder in due course. I'll stand surety to that pile of crap. So we know that the reason why we know that it is 1,100 slave tokens a day. Oh no, approximate. This is approximate, because you can buy your sentence here at €11 a day, which is 1%. And we also saw them go attempt to go to the account that was secured in order, in their presumption, to try to milk it for that amount. So here we've got at the top of the page, nine them events, and underneath we've got 1,100 a day for 28 days times 2. Okay, this is you're working out when they talk about the total cost, the massive cost. This is the massive cost is what they lost, not what, I don't mean in the cost that it cost them to remove us from Hillston Park, to open the courts, to open the prison doors, to pay the security guards, because we all know where all that comes from anyway. Every individual account, every legal fiction account that works for every single one of those agencies is opened and laundered, and there are no costs. It is all discharged. The real cost comes. I'm Her Majesty's government now, right? And I've got a big debt with coronavirus, with Bill Gates, and the indemnity pot that he's had to stump up so that I can continue to appear like I've got some kind of authority. So I have got the, as long as I've got the obligation of performance, that as long as I write everything off, literally, as being COVID, responsible for COVID, I can go to this pot and I can continue this laundry service. And as collateral, I've offered up the people, their rights, their stock, shares, bonds, liberties, equity, everything, legal fictions, rights of use of property, everything is the water, everything as collateral. So, but I've got to keep the door open as a revolving credit facility by writing, saying, yes, it's COVID, it's COVID, it's COVID, it's furlong because of COVID, it's selling that asset, which is really Bonaventure, it's unclaimed estate, it looks like Hillston Park, and I'm using it as collateral. So I'm taking the money out of this hand of the COVID pot, and I'm assigning the right of use or the title deed of Hillston Park and other, obviously the rest of the country, to the buyer, who is buying it at rock bottom price, and discharging 1.7 million. What was the actual figure of Hillston that it was sold for on paper? Can anybody?
That was 1.7 million.
For the main house and 300 for the lodge house.
1.1, sorry, just one.
1.7.
Yeah.
For the main house.
Yeah.
And 300,000 for the lodge house.
I mean, that's really cheap. It's far too cheap. If you are going to go around and sell assets, and you need to sell assets, you have just like they did with the Royal Mail. So here I am, I buy my shares at rock bottom price in COVID and COVID companies, vaccinations, Pfizer. And then what I do is, because I'm now building the everything is COVID belief, that I have now got the ability to be able to hedge my bets. My stock's gone up in all of my products because the narrative of my mouthpiece is corporate governments now singing the same song, that everything is obviously the grounds of the charge against the collateral is COVID. Now we've got very wonderful Judge Stein clearly stating that COVID cannot be used as cause, and it cannot be used to lay a claim with. You can't use COVID as a claimant. She's put that in writing.
Brilliant.
So now she's created a huge problem for Her Majesty's government and Microsoft and biohacks and everybody, the Icon Capital Group, all of it, because of what you guys did. You pushed them in a corner and said, right, even if I am a Vatican debt slave, or I'm going to be implied to be one, you still haven't got the right of use of my equity because I've assigned it to the trust. The trust is under universal law, so I've trumped you at ecclesiastical level now. And then I'm coming down into trust law and equity law. The credit file that you've got that you want to use anyway has got all of its rights reserved. So under here now, I've got 308,000 times 2, because that's 1,100 times 28 days times 2, 308,000. I get it. So this is rough down. If I'm wrong, tell me. It's rough down at the restoration with a pencil and a piece of graph paper that I found in the bin. I'm going to take a picture of it and put it in your presentation pack for you. So, so now we've got 308,000. So 128 and 1191 were responsible for diminishing 616,000 slave tokens off the amount that they had got in their pot for Hillston. Okay, just with the time that they spent in the prison, because it wasn't paid, it wasn't settled, it wasn't, they couldn't open any account. Now, I've got, correct me if I'm wrong here, guys. Emma Venn, who was kicked out at 7 o'clock at night, straight from the prison. How many days were you in there?
He's not here, is he?
You're not?
No.
Okay. So I've got I've got here one Emma Venn was in there for 4 days. Sorry, 2 Emma Venns were in there for 4 days. That gives me 8,800. Then I've got one Emma Venn that was in there for 5 days. That's 5,500. I've got an Emma Venn that was in there for 10 days. That was 10,100. And another one at 10 days, 10,100, and one at 14 days, which is 15,400. So add all of those up together, and we put on the 308 as well. We've got 660.
Isn't the 10,100 11,000, because it's 1,100 a day? So when it's 10 times it, it's actually 11k rather than 10.1.
Oh, bravo. So we'll add another 2 grand on the bottom of there then. Thanks. 2,000 plus 2,000. Okay. Oh, God. So we're going plus the NPC plus 2,000. So it's 1.3. here. I mean, you can work it out yourselves. I'm just giving you the figures. Now we've got 3 court cases at Newport Magistrates Court, which are 30 grand each. So we've got 1 lot at 5 times 5. So we've already got 2 of the Emma Venns out. So the 2 Emma Venns, it's double daily rate in the police station because they're laundering your pot twice. So you've got 2,200, so you've got another 4,400 on to go on there. So now we've got 308,000 times 2, that's 616,000. Then you've got 4,400, and you've got 35,400, and I'd add all of that together with 360,000 for the Newport Magistrates Court 3 sessions, 2 lots of 5, and then 1 lot of 2, and that gives you 360,000. So we've got courts and costs 360, prison and police 653,800. Add that together plus the other 2 that were missed off, and then you can take off 10,920. That's what they made. They made 10,920 because 2 Emma Venns joined it with the name. So they got back, they laundered a maximum of 8,800 through those accounts. And if they could, this is being optimistic on their part, and 2,120 for the fees that so they used the account that they said that they couldn't use 4 times. The application, so it's 530 quid or whatever it was. Was it 530 or 580? Just gone ballpark figure here because it's just ridiculous.
Yeah, it wasn't in the end, was it? That got cancelled. It was just 140 for the appeal.
No, I'm talking about the Habeas Corpus, love.
Oh, sorry. Oh,
And they're
sure.
528 each.
Just talk, yeah, I haven't added that in actually. That's a good point. And that hasn't been processed. We're just talking about what it's cost them so far with the transactions that have gone through. So I would have liked to have gone through, let's say. So now we've got 10,920 is what they've made topside, okay? Because nobody paid it in, they couldn't do the laundry service with the fiat currency 10 to the power of 10. It was just a discharging of the charges of the help with fees account to get it into a position where it was considered. Now what we've got out of there, obviously, is the wonderful exemplification of the fraud where they've used. So don't talk to us, please, about CPR rules. When you've used a national insurance account and said that it was invalid, and then said it was so invalid that you had to make the claims again. And while we're refiling the claims, an answer comes back from the claim that was invalid to say, we don't recognise Minister Imogen, while at the same time, Minister Imogen is being listed as a court hearing in their court serve. Now, this is the most important part. This is the right of use. Instead of you or all of us using something that we didn't have the right of use of, you made them do it. You made them use something that they hadn't created, copyrighted, and had the right of use of. And what did you give them? You gave them an empty credit file that they couldn't launder by using these steps and putting them into practice and exemplifying that you have reached legal majority because you know that much. That all I need to know is that if I use this legal fiction, I keep fiction, and if I use that legal fiction, that legal name that I've been using all my life, I CPR the dead system. I CPR my straw man and up it pops. And then I have to pay for the liabilities of me doing that. So this corporation, now back to the company, Her Majesty's government, looked at that and went, oh my God, get them out of there as quick as possible, because we know that if it does go to a court, then we are acting unlawfully, that the policeman is going to be the one going to the prison. So we can't let it go to the court in that way. We need to keep them as long as we can, break their minds in any way we can with all of these threats and terrible food and all of these things. But know this, every single MFN and every potential MFN who's listening to this, that every time that you do this, you just cost them more than what they made in the exchange of Hillston Park in exchange for the equitable rights of you. What you did is you deleted the profit, you or discredited the administrative system. You didn't just make it not exist anymore, you destroyed it in its own ledger books to the same amount of the whole action of what it had entailed and what it had made in one column by them selling Hillston Park to themselves. So instead, they made a loss, and that is what I've always said is the only way that you can make this system of fictional credit dissolve, disintegrate. The dissolution of it is by not crediting it, and instead your actions that you execute and the deeds that you execute counter credit, let's say, the system, and you are investing your energy in upholding the law. And that's why you've proven to yourselves, I hope you can see, that you're unalienable. She said, we're not recognising liens and charges. Well, so the charge against MFN for liens and charges, we can't possibly consider that, because Judge Stein turned around and said, can't charge Minister MFN. You can't make a charge with it. You can't use it for litigation. And so when you look at that is when you're sitting in the cell and you're thinking, oh God, what have I done? And I need to go home, and know that you have just cost for every 28 days that you're in there, You've just cost that system something that they can never replace, because you have left a massive hole that they can never recuperate, because there is not an account they can go to utilize to fill the deficit up, to make up for that. Now that takes us into exemplifying how the charges of the 10 quadrillion, how did we become the secure party creditors? Okay, you said you didn't understand that, or you didn't recognize that, or you weren't aware of that very fundamental thing that you require to exist in the first place. So you diminished yourself as a corporation. You said that there is no body in the country, in a non-geographical state, once known as England or UK, whatever she called it, that is under unlawful incarceration by coronavirus. That is really, we're going to park that one a minute. I keep saying that because it's just lovely. And we'll go to the what does it mean. So based on what I've just explained there, let's ask some ministerial events. What does that mean to you guys?
Make it commercially unviable for them to continue their corruption.
Yeah.
By exemplifying our rights, by standing up, by exercising our rights and utilizing minister and event.
I completely agree. Does anybody have any hesitation about stating that now as a truth to you, that as Minister MFN, I cannot be used to lay charges against?
Totally agree.
Totally, same.
Totally.
Absolutely.
Yep.
Yeah. That was probably the clearest part of all of it. We can't lay a charge because we can't identify you according to our system.
But I can identify you to say that you don't need a habeas corpus. Wow.
Yeah.
So I know that you don't need a habeas corpus. Why? Because you're Minister MFN. And I couldn't even give you one anyway. So this took me to some things that kept popping out. These limiting beliefs, we'll get to these. So because of CPR and the apparition of admin systems existing in abbreviated commas, and therefore the presumption that itself determined as unlawful at the point of initiation, facilitating a legal remedy to be at the ready implies, obviously, it's the implied presumption of unlawful incarceration that is really inevitable by you using a legal fiction that is copyrighted by that administrative system, breathing life into fiction. And so it's the very reason that a writ of habeas corpus process exists. So the fact that habeas corpus process exists is enough evidence, as far as I'm concerned, and this is what I asked you all to determine for yourselves what you all think. The administrative system, like 128 right at the beginning of this conversation, has exemplified and said that it's proven itself to be unlawful, and without any shadow of a doubt. So if we were going back as a company, let's say, and we were doing a big blue asset management assessment on one of our companies that we just assigned as collateral into our jurisdiction to discharge charges that were accumulated through unlawful commercial intercourse being forced upon people in our communities. And that's how the charges were accumulated of the 10 quadrillion that they then didn't acknowledge in order to undertake any litigation on to discharge the charges with for any event. So the fact that the administrative system has got a code, and that is the reason why we're all incarcerated through it. But she has just stamped to say that that doesn't exist for Minister Mven. So if the administrative system did not unlawfully incarcerate all your minds, and with their procedure, process, rules like registration, regulations, then you would never be able to be presumed to ever require habeas corpus from the unlawful incarceration that comes from accepting administrative code as law. It's just that. So if you don't accept administrative code as law, and you accept and assign your consent to be the Minister of your own energy and matter and movement in all jurisdiction, then you have not resuscitated the legal fiction system, and it cannot commence, process, accept, acknowledge, recognize, and contract with you. That is all the way down. So look at the structure of the hierarchy system now, from ecclesiastical through trust, through equity. They wiped out mercantile law the minute that they didn't acknowledge that another party can stand surety to another party through an assignment of consent. They destroyed their understanding at that level of being able to imply as a trust ever again through mercantile law, Amendment 5. I cannot stand surety to you. I cannot administer your rights, resources back to you any longer, because I just signed a writ, or I just denied a writ that would imply I had any authority to do any of that. I openly exemplified truth about the fiction in my own system, and I rendered myself obsolete. I have no upon to stand on any longer. And that was the point where I realized that she was just gonna wipe it all off. And there was a bit like, oh God, what am I gonna do now if she does that? What are we gonna talk about? Please hang on a minute. And it's that, it's over these last few days, it's like, you know, the administrative system has completely been made obsolete by their own determination, at the level where you're now able to use that document at any point at all, where anybody comes to you to try to lay a charge against you as Minister Mven for litigation. Any litigant purposes cannot be used. And for unlawful incarceration or charges, I can't charge you. I can't hold you in the prison. I can't hold you in a secure facility under the title of COVID, because she quite clearly stated and has written, if you can call it that, that you cannot use that to lay a claim against anything. Well, that, like we said, just banged Bill Gates' indemnity pot with the COVID label into oblivion. So Minister Mven cannot be utilised for litigation purposes, i.e. cannot be used to lay claims with, and not anyone, that includes us, but also not.
Oh, is that like a get out of jail free card then?
Only if you're not breaking the law. If you break
Well, yeah, if you, only
Yeah.
for administrative codes, I mean.
Yeah, well, admin, it's not get out of jail. It's this is my, what am I under warrant? I'm under warrant from universal law to rebut any presumption of adding to the administration of the law being lawful thereafter. It's not. You added to it. You openly exemplified your willingness to protect and uphold the administrative system, even while denying it had any validity to it. It's like I can come over here. What she set a precedence for is that anybody can use legal fiction belonging to anybody, whether you've got a right of use of it or not, is the point that we're getting to. So she just destroyed the whole existence. They exist because they are there to prosecute you, to lay a false claim to something that doesn't belong to you, and that's their legal fiction, and you've used it. Well, they've just leveled the ball game and done exactly the same thing, which means that they just prosecuted themselves into oblivion.
Wow.
Yeah.
As the Gwent police barrister was quoting case law, is that what this refers to, Minister, that it can be quoted as like case law?
It's, in what way do you mean?
Well, you know, like when, say, like if you're having to deal with, let's say, councils or bailiffs, does it set a precedent, as in it's been ruled upon, so it becomes case law?
You've got a dirty certificate offer with an order. You've got an electronic signature of a judge finally on a document to say those things that I've just explained to you there.
Yeah. So it does. I've answered my own question.
It does much more than this is what I wanted to get you involved in this level at this level for, because it's how are you going to present it? What does it mean to you? How am I going to put it into practice? How do I utilize this piece of paper? All right, I've got a piece of paper now that says that I cannot have a claim laid against me. I cannot be unlawfully incarcerated due to COVID, and the minister event is not recognised as a litigation, and that MFM 128 doesn't need a habeas corpus because he's already free, is what it says.
Printing that sheet out and keeping it with me.
Well, it doesn't, you know, what I'm minister of event doesn't say which one, does it? This is the other point which we've missed out. Here is our example of valid ID. Well, I know that that's MFM 128 now. Really? How did you know that? Because his number, that somebody's put MFM 128 on the screen. So you just recognised somebody that you said that you couldn't recognise before as being minister of event, which is, this was one of the questions that I had for you. Wasn't that one of the charges that the police laid against you, that you were being held hostage because you wouldn't identify yourselves?
Yeah.
Yeah, she did say one of the MFNs was present and the other one wasn't.
No, I'm talking about at the point where they were arrested and taken to the police station, and they are saying, I'm Minister MFN. Did the police say to you that you're being held here because you failed to identify yourselves?
That was one of the reasons. And ironically, when they did a search of me, they took my warranty card and the live writ, so they served themselves as well with that.
Same here at me.
So they laid a claim and said that you'd failed to identify yourselves.
Which we didn't, because we're Minister MFN.
Exactly. And so at that point, if that's the reason why I'm arresting you, because you failed to identify yourselves immediately, that's statutory rape.
Yeah.
So at the point where they've then said that you have been incarcerated for one of the charges being that you did fail to identify yourself, and then she has identified you as Minister of Event. Who she identified as Minister of Event, I do not have a bloody clue. It was a voice behind a black screen. She had no way of being able to validate. She didn't ask you to identify yourself whatsoever. And that was at that point where I said the level of presumption here is incriminating.
Well, she even assumed that I was female.
Did you heard the story about the other minister having a male's photograph stuck to the case file that arrived at the prison with a picture of a man? So it's not, you know, if that's valid ID here, and you've used a female's name where you plucked that on from and stuck it to a photograph of a man, and then attached that file to what clearly is a female of the species, and carted it off somewhere and called it legal, and said that you're only here because you failed to identify yourself and you're going to stay here until you tell me who you are. But hang on a minute, you identified me as Minister Ven in a Zoom room behind a black screen without any paper, document, photograph, nothing.
Of course.
So where is my bar standard of presumption? I haven't got one. And if I haven't got a standard, I've got nothing to stand on. I've got no flag, I've got no vessel, I've got nothing. She's floating in the sea. They are the ones now floating in the sea. And you are all joined to another vessel, let's say, in another ocean somewhere. And she gave you the piece of paper that states exactly that. Now, what we're going to go back on, obviously, and keep them busy and give them some more charges and costs that they're going to beg for the discharging of in the end, in order for them to be able to exist. It's not going to be Bill Gates that they're going to become they've already trashed him. They're going to be coming back to the people and begging the people to please accept this offer, and we'll do this instead, and we'll do that instead, because we are now back in the driving seats, administering our own communities and saying, you have not got my share of the planet and its resources, that's it, to do this with. You've got an empty credit file and you can't even use that because the rights are reserved behind it. So even if you do attempt to use the legal fiction that you think belongs to yours, you'll open it up and it'll still cost you because it's an empty credit file. It's got nothing in it except what we've said that you can use it for, which is 528 quid to discharge the charges of the help with fees account. That's it. So the judicial review is obviously driving them into a further, I mean, it's checkmate. We don't have to do anything at all. It's already been done. The charges, however, so we're looking at the remedy now. We've seen the cause, seen the evidence, considered it all. Now we're considering the remedy. Now, in order for us, from my perspective, in order for us to give the best lesson possible, the way that I can see it, is to exemplify how these charges were created that accounted for the 10 quadrillion. So just to remind you, the administrative system, the Schedule A that she actually acknowledged service of because she read it out to herself about the UCC one, about the documents, about the emails. And she denied Her Majesty's government's existence of filing inside the Securities Exchange Commission being relevant to it, which meant that obviously that was the end of them really at that point. So the best way to exemplify this obviously is to demonstrate this is how they were accumulated. So all of you go through the Schedule A, every single book, just took Minister Zimmerman, it's going on YouTube, we're speaking to everybody. Take the Schedule A, absolute, go through the charges, the items that you have been subject to. So how many times have they forced you to use legal fiction, coerced you to commit fraud? How many times have they tried to lay a charge against you for council tax? How many emails have you had to send? Go and work your invoice out, and it is your family trust now invoicing Her Majesty's government for the commercial intercourse that they have forced upon you. We can do it throughout your life if you want. You could start and end point. It can be from the moment that I realized that this is what was going on. If that's I would say the honest point. I can't make somebody liable for something that I wasn't even aware of when I found out actually it was me that was liable. Because what I'm actually doing here is I'm accepting the liability of all of the credit, really. At this point, it's how much did I credit the system? And you're invoicing yourself as the secured party creditor and say, hey, when I was an unsecured creditor of this company, the universal law has secured it, and now I'm coming and I'm saying I'm officially receiving the debt that my crediting caused this system to exist in the first place, and I am accepting it and discharging it against the collateral. Now, right of use now comes into play. So Hillston Park, I just sat around and looked at what it is that I got as compensation when I did this. And I can't define it. I can't put a price on it. It's got no monetary value whatsoever because it's priceless. It's freedom. I'm not even going to try to define it. But in commerce that they comprehend, it's their system. You're speaking to them now. If you could value my energy that I have been assigning the consent of to you to utilize in your system since first knowing that that's what I was doing, that's how much the charges are for the commercial intercourse that you've had from me to date. So now let's look at these people who say, well, the company, yep, it's a private corporation, it's my company. Where are your dividends? Have you ever had any dividends? Have you had any benefits out of it? Have you ever, as an investor of a company that never paid you dividends, I would suggest that you stop gambling on the stock exchange and go and grow some food. And stop pretending that you're a capitalist because you have absolutely no idea how that system works. Stop kidding yourself. Go and do something that you're really good at, because capitalizing on your rights is never going to give you any benefit. So let's all park a line under that. We all can see what that looks like. And now we're discharging the charges of the belief that capitalism was a good thing of our rights. This is what it looks like on paper. So then what we're going to do is we are going to invoice. Not going to invoice them because we can't. We're going to exemplify that if you could pay us, and that this is how those charges were accumulated, because you can't say now that you didn't know that this is what your other agencies and HMCTS and had been doing. And now we've got somebody who is holding the liability, okay, with an electronic signature, but this is to date what this looks like. We told you that we receive your secured party creditors. We told you not to go any further to try to imply that you had any authority to make any determination as a debtor account against your secured party creditors. You said that you didn't comprehend the lien process. So here you are having that exemplified to remedy your unknown state of the very system that you actually created. Here it is in the mirror back at you. Now, because you can't pay us, obviously, in slave tokens, and this is now getting us to the point, how did we end up with the right of use of the Hillston Park, for example, to discharge the charges? So they peacefully surrendered Hillston Park to us. We peacefully surrendered, not peacefully surrendered, but peacefully, that's why it wasn't an eviction, because we didn't peacefully surrender it. They came and used force to force us off the peaceful surrendering situation that we'd already got at the restoration of rights level. They then were, let's say, more peacefully evicted than we were, let's say, as they had a gun pointed in the face and a reasonable force was required in order for us to restore the rights of the creditors again. So the right of use was discharged again. So it went back into the hands of the debtors, and they were holding that surety then for COVID. Now they've found that COVID can't be used as a charge for the grounds clause for any charges to be laid. And so because of these new charges that have come from, really, it's let's call it a webinar training. They've had their universal law webinar training, and this is how much it cost. It cost the right of use of Hillston Park. And I don't know about you guys, but I'd like to see that right of use restored to the family trusts of 128 and 1191. And as obviously the community there for Monmouth area, and if they will accept to take the appointment of that in order for them to put it back into the hands of, the right of use for the community. That's what I'd like to put forward as a suggestion as well.
I think that would be wonderful. Otherwise, all of this would be for nothing.
Yeah.
Yeah.
And this is a receipt. Obviously, they can't lay a claim against you. Here you go. Who are you? Universal Law Community Trust. And you can't lay a claim against me. Your judge said that. Now, if you want to go around again, we're more than happy to do that, no problem. And worse for you, because now there's not just 2 MVNs, there's 9 MVNs who know that even at the worst case scenario, I'm going to do 28 days. And even if I fall down at that point, then I've got to pay you 80 quid. And this has given us so much more than I could have ever expected, because we've got charges laid in the title MVN regarding this matter that they're saying didn't happen. So we've got, if you guys, you know, is it 1191 here?
I did speak to him earlier. He said he was having trouble with his internet.
He is having trouble with his, and he needs a new device to be able to get on it. He can't get on with the tablet that he's got. So we'll have to put a claim in, if everybody's all right with that, to put a claim against the Kindness credit account to get some kind of device, because we can't have him incommunicado.
Yeah, sure.
Absolutely.
So if anybody objects to that, stick it in an email. We'll put, you know, find out how much. I really hate having to invest in phones, but at this point, we need to be able to communicate, and if it's just by Zoom, you know, that we've got at the moment. Now, the other telling thing was that the Queen's Bench, it's only the Queen's Bench can issue a habeas corpus. You all know that, don't you?
Yeah.
Now, the
I
last
do
thing,
know.
and that's the trap. That's the why everything goes. It's like a funnel. It's like a magnet. We're all herded to the slaughterhouse under the heading of admin courts, and over there's Queen Bench, and you can't get to it. Why can't you get to it? Because we're not sovereign anymore. The Queen doesn't exist, so there can't be a bench. The Queen can't. We can't be a sovereign state when everything has been commercialized and we're a corporate state, and we've all agreed to it. So we've gone over that with the payments, we've done the trust law. So this was the thing about, I want to do the thing, I can't do that, but I am. I can't recognize you as then 128, but I am. I want to do that, but I can't. I want to lay a charge against, I want to lay a community protection order against somebody, but I don't know who. I don't know who to lay it against. This is cognitive dissonance at its very finest.
Yeah.
I am denying my own non-existence. That there leaves her with what? A double negative. That's a positive. Because she denied her own non-existence system, she was suddenly back inside universal law. And that's why she didn't know what to do. And that is what you're doing all the time. You're getting people that bash between the eyeballs. Go, I cannot do the thing I'm doing. Hang on a minute, I can't think about being tax-free. Well, why not? You use a rock. Oh, I can't do that thing. Well, what thing is it? Well, I can't do that exchange at point of sale with a token. Well, you just did. You just did. You've been doing it all your life. I can't. Sorry?
Her ladyship had misplaced ballast, because as she left with her vessel, it was very bow heavy with her head. I noticed it.
As a vessel, man, she was swimming.
Yeah.
She was bloody swimming.
It was going down. It was going down bow first.
I think she's lost her job. I really cannot see her. I think they used her as a scapegoat. I think she must have been done something really, really wrong. She looked really sheepish when she came in there, and really, really out of her depth, literally out of her depth, without Oak Shit Creek, without a paddle or a boat. Really, because you don't know what's coming at that point. We told you it was a quiet title. You're going to come and determine. What about a quiet title? Did you not expect, did you really expect us to expect you to be able to deliver something? Well, we've told you the only reason that you're here, and I mean that, to turn around and say, how dare you get me to come here and sit here in Cardiff? Well, I compare that to unlawfully incarcerating 9 people, and you want to talk about coming and parking your house on a chair in Cardiff, to come and tell your admin agents that they cocked it up, but we got rid of the people, we got rid of the evidence. We can't ask for a habeas corpus because we have no body. So really what happened at that point was you were evidenced as being alive as Minister MORHR, if you want to interpret that way.
When the words of armed intruders came out of her mouth, I was looking like really, you know, it was said as though it was like, and children had smarties in the park. You know, there was no weight to what she was saying. There was no, from a judge, from justice, where was the, and what have I just read? You know,
it's irrelevant. She's not supposed to be able to hear you. She's not, so that's why I said, can you hear me? Think what you're saying. Yeah, can hear you. Can you hear me? Oh, well, no. Yeah, can hear you. Oh dear.
Yeah, we're
Oh,
live.
yeah.
Yeah.
And not, oh, you can hear me now. And now you can also hear and identify this voice as MORHR 128. So who is MORHR 128? Well, there's a voice in the ether. Because he can't be the thing that was in the prison, can he? Because the thing that was in the prison was only in the prison because he wouldn't tell him what thing he was. So that can't be him. No, and this is what you need to get your head around. I mean, they at least had a better go of it here. I expected more from them, I have to say. British government, they really let the side down. We had a better go at this with the Hellenic Republic. At least they tried to, you know, lay the charge. They didn't just come out and say, no, we can't charge Minister MORHR. At least they tried to do it here. They couldn't even do it. It's like, just absolutely, under no circumstances can we use this for litigation purposes. But you already did, because MORHR is already on the application that you already stamped and already issued. So you already accepted Minister MORHR as a litigant party to lay a charge and a claim for habeas corpus inside a system that you then turn around and say, oh, I can't do that thing that I just did. I can't recognise Minister MORHR as a legal entity, but I just picked up a document, looked at it. I now took sight of the document that I'm saying could not be filed in front of me to take sight of. And now I'm going to determine about the thing that I can't even see, because the thing that has brought this to my attention, I can't recognise it. Are you completely insane? The level of psychosis there at that exemplification of psychosis cannot, even the most simplest of people must be able to see that for what it really is and was. So now this document that you've got is to be used in all circumstances. To anybody, you know, if you hear that somebody's going and injecting people under the COVID, I have to stop you. I'm very sorry. I'm Minister MORHR. I've got this document here and it's signed by Justice Stein. I'm here to tell you that the thing that you're doing you cannot do, because the reason why you're doing it is not real. It can't be used. Now, if this bit, it just fills me to the brim and more. The COVID as a hypothesis, you smashed it. They can't do it. So here we had the equity. So where was the equity? The belief in the equity, our equitable rights have all been held by the Vatican, came from Helena Elada, the rock. Okay, so now it's over there. Now it's in London being laundered. There's the legal system. And now that's been smashed. They've completely destroyed and dissolved any standing that Washington's got in any bearing, in any commercial activity regarding any legal fiction under the administrative system, HMCTS. Now, what have we got? So it can't be that, it can't be that, it can't be equity, it can't be legal. So what is it? Oh, it's COVID. It can't be that, because she just said Your big boss from the lady of the ship that you're all supposedly assigned to said that, not us. We said it has been being used. And she said, no, it's not. It's not being used. It cannot be used. She put it in writing. It cannot be used to lay a claim. It cannot be used as grounds or cause for claim. They're screwed. So
Where do we find this document?
I sent it to you. Not got it. This is your order. You got there's one for you, whoever you are. One for you, whoever you are. One for you, whoever you are. Whoever you are. Do you get it, guys? You're all Minister of Event, whoever you are. And you've all got a right of use of picking up your own energy and matter and movement and executing it and ministering it in any way you see fit. As long as you're under standing upon and within universal law and you're not doing harm, loss or damage, because if I was, I'd be in the admin system, wouldn't I? That they've just completely made obsolete. So let's see if I can open this document. Well, we've got just popped up with no internet. Let's try again. You still there?
Yeah.
Right, let's see.
I've not received anything.
Yeah, I'm looking for it. I
I
don't
haven't
see
seen
anything
it either.
here.
I've seen everything that's come from Proton, and I haven't seen anything. I haven't seen
Yeah, I'm just looking through my Proton now. I don't see anything.
Somebody replied to me that this is brilliant to add insult to injury. You replied to me.
What was it? Was it an
Once a
attachment that you sent, or?
It's the order from the Queen of the ship, of the sunken vessel. Right, let's open this.
Okay, I have replied, but I didn't see any kind of attachment or anything with it.
Here we go. Let's see. Do this. Okay. You can see that.
Yeah.
Yeah, I haven't seen that.
No, I haven't seen that one.
It's on an email here. Look, it was sent to you. It was sent to you. And you replied to it.
I've not.
This is brilliant.
Okay, where's the attachment though? Where's that document?
On the bottom.
What date was that one? Was that on the 7th,
That was the 11th. Of,
the 11th?
yeah, so this is the one. Look, it's got a red date on it, so it must be true.
Mhm.
And so this is the 128 one.
Okay,
I haven't got that.
Okay, upon hearing the person identified as MVM 128 in person,
In person.
and the person identified as MVM 010. So you've identified MVM as persons here, but then the reason why you've given for not issuing habeas corpus or allowing this to proceed into a hearing is because MVM is not recognised as a litigant. You've identified them as a person. So now we want to know what is the definition of a litigant person if it is not person identified as what? What did you identify MVN as? A person. Where's a person not a litigant? They have to redefine that whole CPR. Look, CPR 87.4. So first of all, upon, what are you standing upon? Upon CPR. But we didn't put any CPR in. We didn't follow your CPR. We just said, you've got these guys locked up here, and you are implying that they're persons, they're misidentified as persons, and persons need habeas corpuses. The applications were dismissed on paper, and they said that they did not know who it was at that point that was laying the claim or who the claim was on behalf of. But here you've just identified them at a hearing. So upon the and you've locked them up in prison. So you made it, whoever it is that you've identified as Right, they, whoever it is who identify themselves as 128 and 1191 ministering, then those are the people that we're talking about. Is the email that they got back, because everybody had a copy of the emails that came in a bundle that said that it was going to be put, these were the documents that they were going to have in front of them.
No.
Like, anybody
No.
not had those
No.
emails?
I don't think I have, because I think you also
No.
mentioned something about a Dropbox as well.
Something about what?
A Dropbox?
There's a Dropbox, but these are, that hasn't gone in the Dropbox. That's the email that came from the court saying that this information was going to be put in front of the judge, and we went, the email back to them says that you've missed off the UCC one, and they'd already added it into a one PDF with, I think, 7 documents attached to it.
Yeah, no, I didn't get that one.
But yeah, has anybody not seen it? If anybody who's not had those 2 documents, email me, please, to the trust email and just forward them on to you. Right, so upon the court noting that the application to make COVID a respondent is misconceived as litigation, cannot be pursued as against a virus. Is there supposed to be a comma? Where is the English Babylonian police for the grammar? What do they call them? The grammar police. Is there, or is there not? I don't know, because I don't use them. As everybody knows, is there supposed to be a comma there? Upon the court noting that the application to make COVID a respondent is misconceived as litigation, cannot be pursued against a virus. There is supposed to be a comma there, I'm sure, from my after misconceived is misconceived as litigation cannot be pursued against a virus.
Yes, it should.
But when you read it all
Yeah.
together,
It's not the first time.
the court noting that the application to make COVID a respondent is misconceived as litigation cannot be pursued against a virus. Well, how are you paying back Bill Gates if he cannot use COVID as litigation? And how can litigation be created because of a virus?
Yeah.
That is the most important one. Needs a big red ring putting around it. Somebody who's good at
Big red rings.
defacing documents, I was going to say, with big red rings.
Send me a copy and I'll do that.
Yeah, put a big red ring around that, because that is all about COVID. That's it. Litigation cannot be pursued against a virus. Okay, so I can't lay a charge against the parousia of the equitable rights of the people in the name of a virus.
So that means the Coronavirus Act is nullified.
Yeah,
Not on void.
Remember already.
it's misconceived.
Isn't
It's beautiful. I love her, this woman. Absolutely love her. I think she'd done this, as a last stand, really. As a last non-standing. We need to offer her a job because she's.
Maybe we should.
I think we should.
She did give you a lot of time where she could have shut you down. Any other judge would have shut you down quite quickly and said, "What are you acting as? You can't be if you're a Mackenzie." Da la la la. Like she did later, but kind of. She just was really gentle with all that, wasn't she? Because she never stopped you talking until she was giving judgment.
She didn't give a judgment. She cannot give a judgment.
Until she decided she was giving judgment.
Incriminated herself.
Yeah.
And what she was doing, she had to go there. She said it herself. I had to come here because of these 2 emails. You're damn right you did. Who are you now? You're doing your job. And who is ministering you? We are. We are telling you that we are not accepting this pile of crap as law anymore. And anybody who is going to go around unlawfully incarcerate people, then you are going to be arrested for it. We put you on notice and we told you that. And you cannot argue. You can only argue with your own shit to a certain level. And at that point, you're without. You've argued yourself to oblivion.
Mm-hmm.
And then to put it in writing like this, I mean, this is what I would really like to give her I want to send it, when I read it, I was like, I said to you, I was going to send her a medal. Let's appoint her Chief, I don't know, something, let's give it a title, Chief of the Quiet Titles. So then we've got upon the court noting that the applicant is not detained. So now Minister Mavell is the applicant. The Minister is not the applicant, is he? I thought Universal Law Community Trust was the applicant, and I thought Porito was the applicant on the first document. The one that you actually stamped has got a Porito on there. And this is the point that what we've done is we've had them prove to themselves that CPR regulations have even entrapped them in it, because they can't perform those stipulations and regulations lawfully. They break the law by their very existence. So here we've got now the bedrock of complete psychosis, that the applicant is not detained, but we didn't recognize the applicant as Emma Venn. The applicant cannot make litigation because Emma Venn is not recognized, but there we are recognizing it as not being detained. Well, how do I know if it's detained or not if I can't recognize it? Could somebody tell me that? I bang my head all weekend, literally on a wall, about this, and because I cannot fathom how is it that I can see that the applicant is not detained, but I cannot recognize the applicant as the applicant. It completely bamboozled me. So that is the logic of administrative CPR.
Is that the meaning of Babel?
It's bloody, it's Babylonian, it really is. It's, I would say, we need to write a glossary for the definition of psychosis is that sentence. Whether by the respondent, I continue, so noting that the applicant is not detained, whether by the respondents or otherwise. What? So who are the respondents now? So whether by the respondents or otherwise. So we put the respondents were Gwent Police, the HM Prison Cardiff and COVID, and all agents using those as cause. So they've only put Gwent Police up. Well, like we said, Gwent Police had farmed us off onto the custody of HM Prison. Where are those? Where are those respondents? And the respondents are otherwise HMCTS, Her Majesty's Government, UK Government Limited, whatever it is that they're going by the title of, Gwent Police are still all using, or they were up until yesterday, COVID as a reason to unlawfully incarcerate you in category D prison conditions. And here you've got her stating that the court noting that the applicant, who is the applicant, Emma Venn, is not detained, whether by the respondents or otherwise. So it's not that Emma Venn is not detained, so therefore it does not need habeas corpus, and the contention that he, in common with every person in the United Kingdom, we didn't say person, is detained using COVID as grounds of cause, is wholly misconceived. So all you've got to do tomorrow is go down to the police station, go down to the borders, the ports, the ticket shops, and say you cannot use COVID anymore as grounds to detain us from passing the ports freely.
Absolutely.
I'll do that at the train station.
What, love?
I'm going to do that at the train station this week.
Yeah, just print these. You can stick. It would be really beneficial to stick them everywhere. You know, on.
Send me it over. Every bus stop I go to, I will stick one up.
It's 2 pages. Upon the applicant and proposed litigation, friends defined as Emma Venn, Minister Emma Venn, Emma Venn 010, or Universal Law Community Trust. Where is the legal fiction that we used, that they actually opened and took 520 or whatever quid it was out for the charges? So we can use that legal fiction for opening the credit file, taking out 580 quid or whatever the charges are for the court with cost for the court, but then it hasn't got any jurisdiction in order for it to lay a claim. Oh dear, what did they just do there? It's not only Minister Emma Venn that's not valid, is it? The legal fiction that was copyright with its last name first and its first name last name first and first name last, is that they've now utilised to take the money out of, that has got the all rights reserved on the bottom of it, of page, I think it's page 5 in the statement of truth that I'm looking at. I understand that proceeds for contempt of court, blah, blah, blah. The claimant believes that the facts as stated in these particulars of claim are true. I am authorised by the claimant to sign this statement. That was ticked, and they confirmed that MFM 128, I believe that the facts were stated in these particulars of claims were true, and that the litigation, friends, was then with a legal fiction with all its rights reserved that had its consent assigned to the Universal Law Community Trust, and it was without merit. So give us a definition, would you, of the word merit? Credit, I'm going to call it. It had no credit in there for them to be able to launder. And that they were warned that if they present further applications that are totally without merit, then they will be a serious risk of being made subject of civil restraint orders. Who are you going to make the subject of? The thing that you don't recognise the applicant? The thing that you used and then said that you can't use in order for you to go and claim with? And that's what she actually said. We don't know who to lay the claim against. Now, if that doesn't tell you that Minister of Event is a quiet title and claims cannot be laid against it, I do not know what it is that you're expecting to ever have in front of you to tell you to stop believing otherwise. Really. And a serious waste, oh, this is the best bit, as this application and the linked application of 1814 has been a serious waste of the court's time. Never mind a serious waste of the people's rights and the people's liberty and time that they spent in the prison being able to exemplify this in all of its wonderful glory, and resources and of public resources. Note that the court's time and resources are separate of public resources in that sentence.
True.
Chief Constable of Gwent Police is substituted, the art of subrogation, as a respondent for the Chief Inspector. Who said you could do that? Who said you could do that? Is that, are we just going to swap that for that? What's the art of subrogation? We're going to swap one legal fiction for another. Voila. No, you can't do that. No, we can't do that. No, we just did. Neither the persons identified as Minister of MFN, Minister of MFN, nor the organisation identified as the Universal Law Community Trust. So now here we are an organisation who is now identified.
Yeah.
And here is Minister of MFN as a person identified 1, 2, 3 times.
Yeah.
But then it's not, then it's identified as not granted, nor the organisation identified as the Universal Law Community Trust are granted litigation friend status in respect for the applicant. Thank you very much. It means that we cannot be a friend of any litigation. We're not part of your litigation system. And who is the applicant? Emma Venn.
Exactly.
The application is dismissed because we couldn't do what it is that we pretended that we could at our shop front. We said, come to us, pay us 500 odd quid, and we'll consider whether we're going to put your case to a court of law that we haven't really got, and you can pay us. So come over here, in other words, buy this misrepresented can of beans, open it up, find out it's not a can of beans, and there's nowhere for you to remedy the theft of your rights to tin of beans. The application is certified as totally without merit. You know, I completely agree. It is without any merit or credit of the administrative system, and it's for you, for them, to give us that is really, it merits a medal, that woman. Thank you.
She's done a great job.
She really did. She's committed fraud there. She's openly admitted that she's switched one title for another. She said that she don't recognise that MFN 128 there, but it was the applicant. Then we've got a run record acknowledging that he is the applicant and that he has assigned all of his authority to act and his assignment of consent into Universal Law Community Trust, which was beautiful. Now, at the point where either I am or I'm not, if I'm saying, like, okay, I'm Minister MFN and I've assigned up my consent to somebody else to act on my behalf, to stand surety to me, I am the creditor at that point, and I've assigned my equitable rights to another to act on my behalf. Now, I would never do that. We would never do that. You would always be doing that, what I did there yourselves. And because the minute that you say I've assigned my consent to somebody other than myself, it implies that that's because you haven't reached legal majority or lawful standing in order for you to be able to execute your own estate, which is why it is so important that people get their head out of the sand and bring them up to speed with just this very simple, basic stuff. That's it. I'm Minister MFN. That's all I've got to say. Now, as a company, I'm sitting there now. My agents have brought me an unwilling customer to my shop. And I say, okay, what's your name? You say Minister MFN. And I'm like, oh my God, there's an alert now on the screen putting Minister MFN. Everybody has been noticed. From the top down, from the House of Lords, all of it. No. Now, that if we want to commit commercial intercourse using legal fiction, we haven't got the right of use of, we end up with this a lot. This is the gamble we're not prepared to take. So that is really your surety. When you go back and you do any of this now, whether it's at Hillston Park, whether it's restoration of rights, anywhere, and any claim that they attempt to try to lay against you, you just pull that out. That's it. That's my receipt. Now, I personally want to go ahead with doing this and pushing them into the corner with the judicial review, where they have to, there's not much further that they can go to exemplify that they're never going to turn around and say, well, I'm saying that, they just did, that we're guilty of fraud, but that's what you're looking at. So for me, there's just one more thing that I'd like to do that I'm not going to disclose on here, because it's going out. In fact, we can stop recording and we'll convene this for issuing the warrant, which is the next step when everybody's considered what it is that they'd like to see happen.